I found out my land had been sold on a Thursday afternoon. I was not expecting to find that out. I was not even looking. I had sat down to check a property tax notice, the kind of routine task you do without thinking, the kind you file away and forget, and in 3 minutes of clicking through a county records portal, the ground shifted beneath everything I thought I knew. My signature was on a deed transfer I never signed, for land I still owned, to a buyer who had already broken ground on it. I sat at that desk for a long time without moving. The screen stayed lit. The numbers on the county record stayed exactly where they were. No amount of rereading changed what they said. 3 years earlier,
Sir,
a developer had forged my signature on a property transfer document, filed it with the county, sold the land to a third-party buyer for $430,000, and kept every cent. And for 3 years, while I paid property taxes on land I no longer legally owned, while a buyer made improvements on land he thought was his, while a developer moved on to the next deal, nobody had said a word to me. If you have ever had something taken from you by someone who counted on your trust, your distance, or your silence, drop a justice in the comments. Because what happened next is the story of what deed fraud really looks like, how it survives as long as it does, and exactly what it takes to unwind it. How you find out your land has been stolen. My name is Ray Callum. The land in question was 48 acres of wooded hillside in the eastern part of the county, land my uncle left me when he passed 11 years ago. I had never built on it. I had not planned to sell it, not yet. It sat there the way land sits when you are not ready for it, patient, waiting, accumulating taxes every year while you figure out what comes next. I paid those taxes faithfully. Every year. Twice a year, the county sent the bill to my address, I wrote the check, and that was the extent of my relationship with Parcel 88 Foxtrot in the years after my uncle died. Which is exactly why it took 3 years to find out. The notice that started everything was not even a warning. It was a routine letter from the county assessor's office informing me that the assessed value of Parcel 88 Foxtrot had been revised upward, an adjustment triggered by recent improvements to the property. Improvements. I had made no improvements. I had not been to the property in 14 months. I logged into the county's online records portal to check what they were referring to. The parcel's ownership record had been updated. The listed owner was not me. A company, Ridgeline Property Holdings LLC, was recorded as the legal owner of Parcel 88 Foxtrot. The transfer date was listed as 3 years and 2 months prior. The recorded deed showed a purchase price of $430,000. I scrolled to the signature page. My name was there. Raymond A. Callum, in typed letters beneath a signature line. And on the signature line, a signature. Confident, clean, the kind of signature that passes a notary's eye. It was not my signature. I know my own handwriting. I have signed my name tens of thousands of times. I know the particular way I cross the A, the way the final M trails lower than it should, the small hesitation I've had since a wrist injury in my 30s. None of it was there. Whoever had signed Raymond A. Callum on that document had practiced. But they had not practiced enough. I printed the page, closed the laptop, and sat in the quiet of my kitchen for a long time. Then I called the one attorney I trusted enough to say the words out loud. "Someone sold my land," I said when she picked up. 3 years ago. And I just found out how deed fraud works and how this one was built. My attorney was a woman named Celine Park. She had handled property disputes for 20 years and had a voice that never changed register regardless of what you told her, a quality I was deeply grateful for in that first phone call. She asked me to bring every document I had related to the land. The original deed from my uncle's estate. The annual tax notices. Any correspondence I had ever received from the county about Parcel 88 Foxtrot. Everything. We met the next morning. She had already pulled the county's recorded transfer document before I arrived. She walked me through how it had been constructed. The fraudulent deed was a warranty deed, the most common type of property transfer. It had been notarized. It listed the grantor as Raymond A. Callum and the grantee as Ridgeline Property Holdings LLC. The legal description of the property was accurate to the foot, parcel number, meets and bounds, everything. Whoever prepared it had access to the real property records. The notarization is the center of this, Celine said. A forged deed without notarization raises flags immediately at the recorder's office. With it, The document processes like any other transfer. She showed me the notary stamp. A real notary seal, license number, county, expiration date. All of it present and correct. The notary either participated or was deceived, she said. Someone appeared before them claiming to be you and presented identification. False ID. Prepared in advance. I thought about that for a moment. Someone had made a false identity document in my name. Had appeared before a notary with my forged signature on a warranty deed. Had transferred my land. Had filed the deed with the county recorder. Had then sold the property to Ridgeline Property Holdings for $430,000. All of it, executed, recorded, completed, while I paid my taxes and went about my life 40 miles away. Who is Ridgeline Property Holdings? I asked. Celine set down her pen. That's the second question. The first is, who knew enough about your land to do this in the first place? She pulled up a second document. A survey report filed with the county 2 months before the fraudulent transfer, a private survey of parcel 88 Foxtrot ordered by a company called Vantage Land Group. I did not recognize the name. Celine did. Vantage Land Group, she said carefully, has been named in 3 prior complaints in this state. 2 were settled quietly. 1 was dismissed on a technicality. They identify underused land with absentee or semi-absent owners, land where the owner is not watching closely, and they move on it. Absentee owner. Land where the owner is not watching closely. That was me. 40 miles away. Paying my taxes. Not watching. Following the money and the documents. Celine filed a title action the following week, a formal legal challenge to the recorded deed, asking the court to declare the transfer void and restore title to me as the original owner. Simultaneously, she filed a complaint with the State Attorney General's office and the County Recorder's Fraud Unit. Ridgeline Property Holdings, as it turned out, was a single-member LLC formed 4 months before the fraudulent transfer. Formed specifically, Celine believed, to receive this transaction. Its registered agent was a man named Davis Crane. Its address was a mailbox at a UPS store. Vantage Land Group was incorporated in a different state, with a different registered agent, and a principal whose name appeared nowhere publicly, until Celine's investigator ran the financial records. The $430,000 paid by Ridgeline to the fraudulent Raymond A. Callum had passed through 2 shell accounts before landing in a personal account belonging to a man named Mitchell Pryor. Mitchell Pryor was also the undisclosed principal of Vantage Land Group. He was also, Celine's investigator found, the man who had ordered the private survey of my land 2 months before the deed was forged. He had scouted the property, ordered the survey, created the LLC, arranged the false identification, appeared before a notary, forged the deed, filed it, sold the land, collected the money, and moved on. When we pulled his records, there were 4 other transactions with identical structures, 4 other parcels, for other owners who, as far as we could determine, did not yet know. Celine looked at me across the table. He has been doing this for years, she said. You are not the first. But you may be the first who caught it in time to stop him. Meanwhile, Ridgeline's buyer had broken ground on the property. A foundation had been poured. Framing had begun on what appeared to be a small residential structure. The buyer, a man named Thomas Webb, had purchased the land in good faith from Ridgeline with no knowledge of the fraud. He had a mortgage on it. He had building permits. He had invested money and time. He was also, technically, building on land that still legally belonged to me. Thomas Webb was not the villain of this story. He was its other victim. What it takes to unwind 3 years of fraud. The title action moved quickly once the fraud unit got involved. The county recorder placed a legal hold on parcel 88 Foxtrot, freezing any further transfers while the case was active. The State Attorney General's office opened a criminal investigation into Mitchell Pryor and Vantage Land Group. Pryor's attorney filed a response to our title action claiming the transfer was legitimate, that the signature had been verified by a licensed notary, and that the burden of proof rested with me to demonstrate the document was fraudulent. Celine had prepared for this. She retained a forensic document examiner, a specialist with 22 years of experience in questioned documents, including signature analysis for federal court proceedings. The examiner compared the forged signature on the deed against 12 authenticated exemplars of my actual signature, bank documents, estate filings, tax records, a mortgage application. The report was 46 pages long. Its conclusion was 3 sentences. The signature on the recorded deed transfer of Parcel 88 Foxtrot does not match the known signature exemplars of Raymond A. Callum. The letter form construction, pen pressure distribution, and baseline trajectory are inconsistent across 17 measurable variables. This signature was not produced by Raymond A. Callum. Celine filed the report with the court on a Tuesday. On Wednesday, the notary who had certified the deed, a woman who worked part-time at a document services shop, came forward voluntarily. She had been shown the examiner's report and recognized immediately what had happened. A man had appeared at her desk with identification in the name of Raymond A. Callum. She had verified the ID, witnessed the signature, and stamped the document. She had done everything correctly by the procedures she was trained to follow. The identification had been fabricated. She submitted a sworn statement to that effect. She was not charged. She had been used. Pryor's attorney withdrew from the case 4 days later. Pryor himself failed to appear at the scheduled hearing. A warrant was issued. He was arrested 14 days later at an airport, in possession of documents suggesting he had been preparing to repeat the process in a different state under a different company name. What justice looks like when 2 innocent people are harmed by 1 crime. The court issued its ruling 6 weeks after Pryor's arrest. The fraudulent deed was declared void ab initio, void from the beginning, as if it had never existed. Title to Parcel 88 Foxtrot was restored to me as the original and continuous owner. The county recorder was ordered to expunge the fraudulent transfer from the official record. Mitchell Pryor was charged with deed fraud, identity theft, wire fraud, and theft by deception. He pled guilty 18 months later to 3 of the 4 counts and was sentenced to 7 years, with restitution ordered to all 5 victims identified in his pattern of fraud. My restitution amount was $430,000, the full sale price of my land, which I had never received, plus 3 years of property taxes I had paid on land the county had already transferred out of my name in its records, plus documented legal fees. But there was still the matter of Thomas Webb. Thomas Webb had bought land in good faith, had a mortgage on it, had a foundation poured, had framing up, had building permits signed and inspected. He had done nothing wrong and stood to lose everything he had put into a piece of land that was no longer his. Celine and I talked about this for a long time before the ruling came down. The law was clear: a forged deed transfers nothing. The land was mine. Pryor had no title to give Ridgeline, and Ridgeline had no title to give Thomas Webb. The chain was broken at the very first link, and everything downstream of that break was legally invalid. But legal validity and human reality are 2 different things. I contacted Thomas Webb through Celine the week before the ruling. I told him I understood he was not responsible for what had happened. I told him I was not interested in taking land from a man who had acted in good faith. And I told him that if he wanted to negotiate a legitimate purchase, at fair market value, properly documented, with a clear title, I was willing to have that conversation. He called me directly 2 days later. His voice was quiet and careful, the voice of a man who had spent several weeks not knowing if his foundation was going to become someone else's property. "Why would you do that?" he asked. I thought about it for a moment. "Because the land did not make me the victim," I said. "The fraud did. And the fraud is dealt with." We signed a legitimate purchase agreement 3 months after the ruling. Proper deed. Proper title search. Proper notarization, with me present, in person, signing my own name. Thomas Webb finished his house. I used the proceeds to buy a different piece of land, farther out, higher elevation, the kind of place my uncle would have approved of. And I set up annual title monitoring, the kind of service that alerts you within days if any document is filed against your property anywhere in the county. What to take from this? Because here is what I know now that I did not know 3 years ago. Deed fraud does not announce itself. It happens quietly, in county recorder offices, in the gap between how often you check your records and how fast a determined person can move. It targets land that is real, valuable, and unattended. It targets owners who trust that their name on a deed is protection enough. It is not. Your deed is only as safe as the last time you checked it. Go look up your property right now. Today. Your county has an online records portal, Search your name and your parcel number. Check who is listed as the owner. Check that no liens, transfers, or encumbrances have been filed that you did not authorize. It takes 4 minutes. It took me 3 years not to do it. Do not be where I was. If this story made you stop and think, if it made you want to go check your own records, that is exactly the right instinct. Drop a justice in the comments and tell me whether you found what you expected. And if you want to know what happened to the other 4 victims in Pryor's case, including the one whose rental income was being redirected for over a year without their knowledge, that story is coming. Subscribe so you are there when it drops. New Frontier Justice every week. The land remembers what people try to erase. So do documents. So do the people who know how to read them. I'll see you in the next one.